Hi, I'm Huck. And you know, this whole issue over ObamaCare is really a question of whether or not the federal government, under the Commerce Clause and other relevant provisions of the Constitution, is empowered and has the authority to establish rules for the private health insurance industry, and, more importantly, whether Americans can be compelled by the federal government to buy health insurance. The argument for it is simple. Without it, costs have skyrocketed. Health outcomes and lifespans are poorer than virtually all other countries with such centralized government controls of the healthcare industry. And the cost of providing medical care for those without health insurance is the leading cause of bankruptcy in America. It's affecting businesses' ability to compete in the marketplace, and it constitutes the greatest portion of state and federal budgets. No one disputes that the lack of health care insurance for maybe 50 million Americans has adversely affected both the cost and accessibility of healthcare services for everyone. Not even the government's opponents in court have disputed the right of the federal government to implement a Medicare for all healthcare system in the United States. That would be a given. But does the Constitution empower Congress to compel Americans to buy into the private, for-profit health insurance industry even against their will? Or are only states able to do that? And if some states refuse, as most states have, can the federal government then step in? The arguments against Obamacare are pretty simple too. Opponents say nothing in the Constitution, including the Commerce Clause, can allow the federal government to force people to purchase a product against their will. Put another way, in even simpler terms, what the opponents of Obamacare are arguing is that those folks who currently are not purchasing healthcare insurance are not involved in commerce. And so, whatever provisions the Commerce Clause permits the federal government, these folks, not involved in commerce, should be exempt. So which is it? What does the Constitution say? Previous Supreme Courts have a rather long and extensive history of ruling that indeed the federal government can require citizens to do things against their will. Pay into a retirement program, Social Security, pay into a future health care program, Medicare, pay for the medical care of the disabled and the poor, Medicaid, as well as a host of other mandated participations. For instance, it was the same Commerce Clause at the very heart of this debate that was used in the 1960s to force businesses in the South to have to serve blacks and other minorities in restaurants and hotels, whether the owners of those businesses liked it or not. And It was the Commerce Clause that has been used for decades now to break up monopolies and enforce antitrust legislation due to their adverse effect on prices and competition of interstate commerce. In each case, these powers of the federal government brought conservatives out of the woods, fuming and challenging these acts in Congress as unconstitutional. They argued that each of these laws and programs were an overreach by the federal government, an infringement on states' rights. And in each case, various Supreme Courts over the years have ruled that these naysayers are just wrong. So here we are again. Only this time, this case comes before a Supreme Court with 5 conservative members who have shown a stunningly narrow view of the Constitution. If you are just one in the vast majority of Americans who are dumbstruck at the exceedingly extreme laws being passed and proposed by conservatives at the state and federal level throughout this country in recent years, well, welcome to the fuel that feeds that fire, the U.S. Supreme Court. There have always been a mix of conservatives and liberals on the High Court, but perhaps none has gained such notoriety in key cases for seeming to be politically, ideologically driven rather than forming opinions based on constitutional concepts. From campaign finance reform and gun laws to women's reproductive rights and affirmative action, the John Roberts Supreme Court has shown no hesitancy in overturning decades of established precedent and constitutional law for a completely different point of view. Conservatives credit this to justices who are originalists, who interpret the Constitution in a way it was originally meant by those who originally wrote it at the time it was originally written. This as opposed to less conservative perspectives, which liberals tend to do on the court, which is to see the Constitution as a living, breathing document with room for expanding interpretation as societal norms, economic influences, and science advance. Among current court members, Justice Scalia and Thomas are avowed, devoted originalists. And not surprisingly, this makes them the 2 most conservative members of the court. Though still fairly early in his term, Chief Justice John Roberts has shown a tendency, at least in key cases, of having originalist views himself, leading many to believe that these 3 justices may lead a revolution on the court, overturning decades of established law in antitrust legislation, civil rights legislation, and other areas that have been around since the New Deal. Originalists believe only the meaning of the Constitution as it was understood at the time of those writing it should have any bearing in a judicial review. This original intent and textual meaning cannot be expanded upon, they argue. But there are big, very big problems with this approach. In the whole time-honored history of law, not only as practiced in America, but even as far back as its roots in Old England, has been to honor precedent and to build upon that framework. Originalism, by definition, disregards precedent. In fact, seeks to erase it as if it never happened. They favor instead this much more narrowed scope of original intent, original meaning of the words written in the Constitution. Ironically, since no expressed or inferred provision within the Constitution, and certainly no law ever enacted by Congress, grants authority to the courts to review legislative actions, originalists cannot, by their own definition, be empowered to review the Affordable Care Act or any other piece of legislation. Ever since the case of Madison versus Marbury in 1803, the courts have done just that. And the result of the reviewing laws passed by Congress and state legislatures has been very much a mix of very good and very bad decisions. The debate over the legality of judicial review, whether the courts even have any authority in upholding or overturning acts of Congress, really has always been under debate and continues to be debated, but has been largely accepted as an established, entrenched, unenumerated power of the courts. One thing is certain, however: a true originalist on the court, you would think, should recuse himself from any judicial review of a legislative act on grounds that they lack the authority specifically granted to them by the Constitution. No originalist, of course, has ever done that. It seems originalists like Justice Scalia and Justice Thomas have no qualms about limiting the powers of Congress and other legislatures from overstepping their authority based on this very narrow view of the Constitution. However, the same rules don't apply to themselves and their own unenumerated powers. Go figure. I don't mention this as a knock on judicial review, which, as I said, has been established and entrenched for decades now by precedent of the court. However, it does point to the absolute absurdity of using an originalist concept of interpreting the Constitution. The truth is, the whole process of judicial review does deserve more scrutiny than it gets, as evidenced by the myriad of decisions that have been handed down since the formation of this country. As often as not, some very key important decisions seem to be the result of political ideology seeking out some justification within the Constitution, rather than a real look at the Constitution itself. Bias be damned. Putting all of that aside, however, one of the huge real problems for originalists in interpreting the Constitution is the fact that our forefathers, as revered as they may be, were far from perfect. And they knew it. They did, after all, write into the very framework of the Constitution an expressed legalization of the abhorrent practice of slavery. So embedded within the Constitution, in fact, that they made it impossible for any act of Congress to legitimately end it. No, only the ratification of an amendment to the Constitution could abolish slavery, and amendments are a very heavy lift, requiring more than even a supermajority of the states to individually ratify them. That is why these most brilliant forefathers of ours must ultimately be held responsible for leading us just 72 years after writing the Constitution into this nation's most brutal war. A war amongst ourselves. A war which took 600,000 lives. A war in which, on a single weekend in Gettysburg, more casualties occurred than in the entire 10-year conflict in Vietnam. That war, by the way, served to settle, for all intents and purposes, much of the questions surrounding the Constitution's empowerment of the federal government as opposed to states' rights. It should surprise no one that in some circles, particularly conservative circles, that war is still being fought. And some conservatives still mention succession. And it is the philosophy of originalism, not libertarianism, that motivates people like Senator Rand Paul, who are suddenly calling for a restoration of segregation in the South and erasing 70 years of civil rights legislation in the process. But in some ways, our forefathers were brilliant. While much of the Constitution is crystal clear and nearly impossible to misread, portions of the Constitution are expressly and purposefully less clear. The Commerce Clause and the Necessary and Proper Clause, the fine line between states' rights and federal authority, the perceived right to privacy, and due process are just a few of the gray areas within the Constitution left for us to decipher. In their wisdom, the authors of the Constitution realized they could not possibly foresee all that might someday confront this nation. And these gray areas left room to maneuver, sometimes in one direction, sometimes in the opposite direction. Conservative originalists refuse to accept the idea that gray areas exist within the Constitution. At least, they don't accept the premise of gray areas within the Constitution whenever it interferes with the conservative agenda. Sometimes, originalists, like Justice Thomas and Scalia, have to reinvent the English language, or completely ignore, as if they don't exist, very clear provisions within the Constitution to make it all work. But these are, after all, some of the best attorneys money can buy, coming from some of this nation's most elite, prestigious institutions. So twisting the legal arguments to fit a specific agenda comes pretty easily in these circles. That's what lawyers do. And in part 2 of this series, coming later this week, I will explain exactly how they do it, with specific examples and specific case law where they have done it in the recent past. And I will explain as we examine the oral arguments presented in the case against Obamacare before the Supreme Court, of why this weak and often illogical approach to interpreting the Constitution will receive much more scrutiny from the public than in most cases that have come before the court in the past, and what that will mean for the chances that the Affordable Care Act will be either upheld or overturned. In part 2, I hope to examine not just the Constitution and how liberals and conservatives can reach such opposite conclusions, but I will examine how conservatives, not liberals, are legislating from the bench. And finally, in part 2, I will look very closely at this case against Obamacare in the Supreme Court, the arguments presented by both sides, and what it is that's at stake. I'm Huck. Thanks for watching. I'll see you again real soon.